I'm Phil Albart. I'm a member of the Triangle Lawyers chapter. I have the unenviable task of introducing two men who need no introduction. Judge Dever has been a United States District Court judge in the Eastern District of North Carolina since 2005. Judge Boyle celebrated 40 years on the bench in May of this year. And to put that into perspective, and I'm going to be brief because I don't want to get in trouble. In 1984, when Judge Boyle took the bench, we were closer to the moon. 1984 is closer to the moon landing than we are today to 9/11. That's how much has changed since Judge Boyle has been on the bench. I wasn't even born. There was no me. And I think that's really as much as I can say. We'll leave it to the two gentlemen to carry on from here. Thank you all.
Well, thank you, Phil. And I also want to echo your comments and add my congratulations to Judge Boyle and my thanks to him for his 40 years of service. To add a little more perspective to it, he is there have probably been about 2,500 Article III judges in the history of the United States. He is the 17th United States district judge to serve as an active district judge for 40 years. So that, I think, is worthy of a round of applause in and of itself. And he was kind enough to agree to do this. Those of you who know Judge Boyle know that he is a truly humble public servant. So let's sort of get it started. Can I
interrupt?
Yes.
Do I need to have counsel appointed representative?
No. Okay. So you're an undergraduate at Brown. You're playing football. You're studying. Graduation is coming. How is it that you decide to go to law school?
Well, I was going to teach high school history and be a football coach. And I had a roommate who applied to law school and had some applications floating around. And I looked at some of them, and one of them didn't require an essay. So I filled that one out and sent it in. And a couple of months later, or two months, I found out I'd been admitted to law school. And I called them up and said I didn't want to come right then. Could they hold it over? And they said, no, you either come or you don't. And so anyway, that's how I got into law school. I had no expectation of being a lawyer. My dad and his brother were both lawyers. I was going to strike out on my own.
And so you go to American University, and what's your law school experience like? Did you work on the Hill during school?
Yeah, I had a mentor who went to Brown and graduated 30 or 40 years before me. He was a congressman from New Jersey. I was born and raised in northern New Jersey, and he was always someone that tried to advance my career and my situation. So I went to see him, and he said, go to school for 6 months or 4 months, and when you finish, come see me and I'll put you to work. So he was the ranking Republican. He'd been in Congress for over 20 years. He was the ranking Republican on the banking committee, banking and currency, and I did my first semester in law school, and then I went to see him, and he said, I'll give you a position on the committee, and he hired me to go to work in the House of Representatives. So starting in March of 1968, March 1st, I had a job, and I was in law school. I went days. I tried to put together my curriculum so that I stayed current in law school, but I worked as much as I could, and it was great. I mean, Lyndon Johnson was president, the Great Society was going on. We had lots of important legislation. I can vividly remember living in Washington in April, on April 4th, when Martin Luther King was assassinated, and then on June 18th or 20th when Bobby Kennedy was assassinated. So it was a time of great upheaval. There was the Poor People's March on Washington. They had converted the mall into a protest area, and it's really interesting. And to me, reflecting on things now in the past couple of years, there were bad things in the 60s that happened, but we weren't as immediate. We didn't touch them as closely. And I think, what America goes through is cyclical, and it's coming around again.
So you finish law school, and what do you do immediately after you graduate?
Well, I became a counsel on the committee and stayed working there. And during that period of time, I met my wife, who came to Washington, and she worked in the House of Representatives too. And we fell in love and got married. And her father was Tom Ellis, and he was running the Helms campaign for Senate. Helms was running against Nick Galifianakis, who had beaten Jordan in the primary, and it was the Nixon 72 election. And so there was a landslide for the Republicans all over the country. And I worked with him during the campaign, and when Helms won and Nixon won, we decided that it was time to leave Washington and we would move to North Carolina. And I had taken the bar in Washington and passed it in 1970, so 54 and a half years ago. And then I took the bar again, which was not what I wanted to do. But I had to, because you couldn't waive in. And I took it in North Carolina in 1973. And so last year, I didn't go to the ceremony, but I was in the 50th anniversary crowd. So I passed the bar, and I went to work in Helms' Washington office as his counsel. And I was there at the beginning of his term and stayed through that year. And we decided to move to North Carolina, and we picked a town that the Ellises knew. They had friends and relatives there, not relatives, but friends. And we moved to Edenton, and I was going to hang out a shingle, but that was not a very smart thing to do. So I made contact with Dewey Wells and Tony Hornthal, who were prominent lawyers in Elizabeth City. It was one of the two A-rated firms, and they took me in as an associate for 6 months. And after 6 months, they didn't say anything, and I stayed. And they made me a partner 2 years later, and I practiced general practice of law in Elizabeth City and the 8 or 10 surrounding counties for 10 years. And I know on your questions, you say, what was your practice like? Well, it was everything and anything. And some things I didn't know how to do it, and I still did it. But it was a very general practice, trial practice. I represented criminal defendants. I represented insurance companies. We went to court a lot. It was a little different than it is now. Most things would end up with a trial of some kind or another. So April 3rd, I think, is the date of 1984, to sort of give people a sense of what the nomination and confirmation process used to be like. April 3rd, 1984, you get nominated, and what's the process until you're confirmed and appointed? Well, it started in December of '83 when Frank Dupree, who'd been on the bench for about 15 years, took senior status. And Helms' office called me immediately. I had no idea, no interest, and said, the senator's going to send your name to the White House. He wants you to be a federal judge. And I said, okay, that's that's fine. And he did it. And so no one really knew who I was. I got good reports from the lawyers that I'd practiced around. And so January and February, it went to the ABA and they reviewed my stuff and they passed me. And on April 3rd, was it? Yeah, Reagan called and said he was going to nominate me right then. And I said, that's fine. And I called Helms' office. They said, well, you better get up here to Washington right away, because that was a Thursday probably. On Sunday, I flew to Washington from Elizabeth City, or from Norfolk. And they took me to the Judiciary Committee and set me up with Thurman's guy who was running everything. And they said, you'll be back here Wednesday. So I flew up Monday, came home, flew back Wednesday, had lunch with Mrs. East, John East's widow or wife at the time, in the Senate dining room, and went in and had my hearing. And the interesting thing, looking back retrospectively over my life and career, was Thurman was so smart and savvy and in control of the Senate. He paired me with a guy named Joe Longobardi, who was from Delaware, and Biden was running for re-election in '84. And he wanted this Republican of the Delaware court. He was a judge in Delaware. He wanted him confirmed because it helped him in his election. And so Biden was at my hearing with Thurman and East and Helms. And he didn't say anything. He just, sort of looked stern at me. But we got through together, and it was April 23rd, maybe, that the Senate confirmed. The Easter came in between, so they went home. But I was nominated, had a hearing, and was confirmed within 21 days. Which is the way it, used to be, I guess. Certainly wasn't that way later, but that's the story.
So you joined the court in 1984, and we're gonna get to sort of to some cases. But when you joined the court, what's the court like?
Well, the court's got Fox, who came on in October of '82. So he'd come on maybe 15 months or 17 months before me, and Britt, who'd come on in May or April of '80. And Britt was the chief, and Fox and I were the two other judges, and Dupree and Larkins were the senior judges. And it was a very tense court. There was a lot of political friction in the court, to be frank. And so we started having, once I got on, there were 3 votes instead of 2 votes. While Britt only had Fox, he could do whatever he wanted to, and he did. So when I came on, he was having a bench conference every month. Bench conferences are bad. In the 10 years that I was chief judge, I don't know that we ever had a bench conference. I would just call people and talk to them. And, when you get judges together, it's just not a positive environment. And so we started having bench conferences every month. And Britt would invite in all the people. He'd bring in the probation and bankruptcy and marshal and everybody. So there'd be a big crowd there, but there were only 3 of us that had a vote. So I've decided to vote no on everything that he presented. And it confused Fox, and he didn't know whether to vote yes or vote no, and then he started voting no, and so Britt was losing every one of his votes, and that was the end of bench conferences.
So when you one of the things that is certainly true that's different from 40 years ago, give a sense of how many cases for example, you tried to verdict in your first or second year on the bench.
As we talked, the first year I was on the bench, now we're very kind. We let the new judge start off and just build up. They gave me all the junk. Absolutely every bad case that had some time on it, I got. So I tried 35 jury cases the first year. Last year, I think I tried 5. So that gives you a perspective about how declining the jury trial situation is in federal court.
And Gerald Gunther has a wonderful biography of Learned Hand, and Learned Hand, of course, was on SDNY for 15 years and then on the Second Circuit for, I think, another 37, not all active. Some of that was when he was a senior judge, but as Gunther's book shows, and then as your 40 years reflect, essentially all of the issues of society ultimately find their way into a courtroom. And many of those have found their way into yours over the last 40 years. So I just wanted to sort of shift to some memorable, when we think about your kind of environmental cases, you've had so many sort of across the spectrum over the last 40 years. Do any of those stand out to you?
Well, I live in eastern North Carolina. I live on a river and in a very rural area, and nature is present everywhere. And so I've always felt like I have a special duty to the environment and that part of our process. And so the big ones that were controversial and important were the OLF landing field, which they were going to, the Air Force was going to put in several counties in North Carolina. It would have completely interrupted the waterfowl population and was actually dangerous for the pilots too. And I entered an injunction, and it was funny. I gave the environmentalists everything they asked for, 100% of what they asked for. And I gave the Defense Department nothing because I knew that the Fourth Circuit wouldn't affirm me if I picked and chose. But if I gave a blanket thing, they would cut it back and put their hand on it, put their imprimatur on it, and it worked. And so that was a big case. Beach driving is another case. There were no permits required for people to go on to the Outer Banks, the government-owned property. And every year there would be 1 or 2 dead people from people abusing that process and driving and drunk and whatever. And so I had a case that I basically initiated by finding a guy guilty of not having a permit to drive. And the government actually followed up on that, and they had a permitting process. And now if you want to drive on the national seashore, you have to get a driver's permit, which did a lot to save lives. I had the case where they moved the Hatteras Lighthouse, which was a big thing, and I've followed or had cases for the last since '97 involving the red wolves and their possible extinction, and that case first went to the circuit court in '97, and they affirmed the rulings that I made to preserve the red wolves, and that's been an important case. That's about it.
Okay. When you think about some of the more memorable criminal cases that have come your way. We'll talk about some of those cases, and that'll be a good segue into sentencing after that. But do you have any sort of memorable criminal cases that come to mind over the last 40 years?
Well, there was a notorious case in the late 80s. I think it was in 88 or 87, 8, and 9, the Eddie Hatcher case where two people took over the Robisonian newspaper and held everyone hostage 20 people hostage for a day or a day and a half, and it was on national news, and it was a cause célèbre. And I tried that case to verdict, and they were acquitted because Kunstler was in. Anybody ever heard of William Kunstler? You got to be around a long time to remember him, but he was a famous civil rights and lawyer. He was in that case. Another case along those lines was the White Patriot Party. That was in the 80s too, and they were a bunch of radical sort of, I don't know what you'd call them, they were trying to blow up things on Fort Bragg, and it was a big case. The Plowshares was the part of the Berrigan crowd. Philip Berrigan, who had been in the Chicago 8 in the 60s, he was one of them. These were Catholic activists who went on to Seymour Johnson and beat the nose cone of fighters with hammers, and under the biblical statement of beat your swords into plowshares. And had the tarnished badge cases involving all the Robeson County Sheriff's Office. And a CIA case, the Pizarro case, after the Abu Ghraib, they cracked down on torturing people who we were holding in Afghanistan, and one of the CIA operatives got prosecuted in the Eastern District because of Fort Bragg, and that was a very unusual case.
So you came on the bench at a time prior to the guidelines becoming mandatory in 1987, and then of course you've been on the bench when Booker gets decided in 2005. So you were sort of there at the beginning, where we have a completely indeterminate sentencing scheme, which was essentially the law in federal court from the founding until the adoption of the Sentencing Reform Act, and then the guidelines becoming mandatory in 1987. So just describe your impressions of the sentencing process as you reflect over the 40 years.
Well, I've always been an enemy of the guidelines, and that's known within those who practice in front of me. And I think it comes from my exposure earlier to having to decide sentences on my own with the help of the probation office. Sentencing is the most important thing we do. We're in controlling the lives of people involuntarily, and it requires a collection of different factors, from justice to saving society to protecting the innocent to being merciful to the accused, protecting the victims again. I mean, there are so many factors that go in, and it's such an important thing that I don't mean any criticism by this at all, but I always felt like the guidelines gave you an escape hatch to use and say, well, I didn't do this, the guidelines did it. And I just have never been a big fan of them, and they're, I think, arbitrary, and it's just to me, not a helpful thing. But I go through the process. I sentence people before Booker. I've sentenced people continuously. I sentenced people today, this morning. I don't know. I think that Mistretta was wrongfully decided. Scalia, to his credit, voted in dissent. And, the bill was S1. It passed in 1984 or 7. Four. And it went into effect in 87. And the sponsors of it were Kennedy and Thurman. And, if Kennedy and Thurman, Teddy Kennedy and Thurman, if they were together on something, I'd be suspicious.
That, of course, one of the principal authors of it prior to his appointment was an administrative law professor from Harvard on leave to the Judiciary Committee in the late 70s named Stephen Breyer. Sort of a little bit of a Paul Harvey rest of the story on the Sentencing Reform Act. So when you think about advocacy at sentencing, and I know some folks here practice in federal court, and is there anything that you think, things that are more effective or less effective, and we'll sort of broaden it out beyond that to other topics in litigation?
Sentencing, per se, yeah. I want to hear from the defendant, and I will talk to the defendant, and it's a good thing if I'm talking, not a bad thing. It's not critical. It may sound critical, but what I'm trying to do is to get a feel for who this person is and where they are right now. Are they conscious of their wrongdoing? Are they realistic about it? Do they have they made a firm resolve to change? How does what they do impact on society, on the community, on the victims, the people that were impacted by what they did? So I don't take a long time, but if you see me start to talk to somebody, don't shut them up, because I need that. I need all the help I can get. And so in every case, you have to have allocution, or you give them the right to allocution. That I pay attention to that. I want to know.
So broadening it out a little bit, you've obviously tried, hundreds and hundreds and hundreds of cases to verdict over the last 40 years. What advice would you have for lawyers about handling cases in front of juries, and then we'll talk separately about handling cases in front of you?
I think you need to be honest and forthright and candid with juries. Jurors are suspicious. They've been called in. They've never been in a courtroom before. I try a lot of cases in Elizabeth City. I've tried cases here over the years, and cases in New Bern and Wilmington and wherever. I even tried a case in Fayetteville. I think that the lawyer needs to relate to the jury and be open with them and get to the point and be sincere and be candid. All the things that are important in your relationship with other people are important with your relationship with the jury. It's funny, you never know what the jury's going to grab onto. We sometimes eavesdrop on the jury room in Elizabeth City because there's a vent that you can stand around. And, rarely are they talking about what happened in the case. I'm serious. Usually what they're talking about is what their brother-in-law told them and how, his experience was like this guy's experience, and things that are just off the wall. And after back in the 80s, no, not 90s, I'm getting confused with it. who was the guy that drove all around it, the football player, O.J. Simpson.
yeah.
After the O.J. Simpson trial, that so poisoned the environment that I couldn't get a verdict. I had hung juries like 3 or 4 in a row. Every time you'd have a criminal trial, that somebody'd say, well, I don't know. I think he might not have done it. That had a big impact on juries.
How about for advocates in thinking about presenting cases to you as the person making a decision?
Well, as we talk about all the time, every case has an issue, or every side of a case has an issue. None have more. And so you need to be bold enough to isolate the issue that resolves the case in your favor. And if there is such an issue, and you need to follow that and limit it to that. Don't be distractive.
When we think about your civil cases and just sort of the variety of civil cases that you've had through the years, do any of the civil cases in sort of the non-environmental context, do any of those come to mind?
Yeah, I've tried the innocence case of McCollum and Brown, which was a big case here in Raleigh about 3 or 4 years ago, and the 2 brothers who were on death row for 31 years, were actually innocent, and they got a verdict of $70 million, which was the largest verdict ever, I think, for a wrongful incarceration case. Back in the 90s, I had the Glaxo-Zantac patent case, and Zantac was a national product or international product with $6 billion of sales a year. And we tried that in Elizabeth City, but there were a lot of prominent lawyers in that. I've had a long history of credit card cases with the Soldiers and Sailors Relief Act and banks that charge extra duties on that. And there was the North Carolina copy of the Bill of Rights, which was sent by Washington to the governor of North Carolina in 1788, right after the bill, I think in April or May of 1788. North Carolina was not in the country. We had refused to ratify the Constitution at the Hillsborough Convention, and they were waiting the next convention to come up, which was a year later in Fayetteville. And the people from the Antiques Roadshow, one of the principals in that, was involved in the sale of it. And anyway, there was a big lawsuit that seized the Bill of Rights. Ultimately, I had an order that gave it to North Carolina because it was our property.
And I know that you take the time out of your schedule to speak to both the summer interns and then the new law clerks on the court. And I know you're a big reader. What books would you recommend to lawyers and law students that you have found to be both helpful and memorable to you during your time as a federal judge?
Well, my favorite book is To Kill a Mockingbird, and one of the other favorites is They Called Him Whizzer, that you lent me. And Whizzer White was a wonderful example of what a judge should be. And first, the Sandra O'Connor book is another really fine book. And I've read, I gave Phil, I think, the list of books. I've made about 15 copies of a list of maybe 45 or 50 books that I've handed out at different times. I add to it as I read more. But anyway.
What would you say the biggest differences are? So you come on the bench in 1984. You still have a probably as full of a docket as you've ever had, I suspect, as a court. I know our court has a lot of, each of us has a lot of cases. What have you seen that's changed most significantly? What has sort of remained the same?
Well, technology certainly has changed. I'm a Luddite. I try not to use any if I can get away with it. But it's hard to escape it. And I don't know that it's improved the situation. I kind of like the way it used to be. But we have fewer trials and more work. And trials, don't get me wrong, if you're in a trial, you can't do other things. At least you can't do them while you're sitting on the bench. And so having a lot of jury trials and long jury trials takes the judge out of chambers. And I'll do this for you. I'm a quick trial judge. There are two kinds of judges in the world, fast trial and slow trial. And when Fox came on, and for years, when I was the chief, he would have 20, 30 jury trials during the year, and he would have them backed up, and I volunteer to take them, and I'd take them, and he'd still have 30 or 40 because he liked having trials. He didn't want a guilty plea. He wanted a trial. And so I'm a fast trial judge. I pick a jury by 11, and we're into the evidence. And at 4 o'clock, we're finished with closing arguments. And I'm serious. A couple of months ago, I tried 3 cases in a week to verdict. My record is 4.
What are the keys to being a quick trial judge, would you say?
You just have to move it along and don't let them waste time. And you have to take control of the case. They're going to either affirm you or reverse you no matter what. So you might as well, take the stinger out on your side and let them worry about it. But I don't put up with the government or the defendant wasting time. Next witness, okay, next witness. And I have the list of witnesses and I'm checking them off. And there may be 14 witnesses and I'm down to 10 by 2 o'clock in the afternoon. So.
And in conducting, have you seen what have you seen among the more effective advocates who are trying to try cases in front of a quick trial judge?
Well, to distill it down to its essence, I mean, my belief is that jurors only understand what we're doing from television and movies. They've never been, if they've been a juror before, they probably get struck. So you need to conform. The TV program's an hour, and they get a verdict, and you need to conform how you present to the image of what they expect.
And how much do you think? And I will say, to sort of sharing one of my own observations, is that especially in civil cases, there's so much that you learn in discovery as a lawyer, and part of you have this instinct, you want to share how much you know. It's not a good idea for a jury or ultimately for your client, right? I mean, and have you seen that as sort of the discovery process and increased discovery? Have you seen that as adversely affecting the quality of the advocacy that you've seen over the last 40 years?
Absolutely. I'm the enemy of discovery. So I will cut it back to nothing. And if it gets to me and you're resisting discovery, you're going to win.
I think we're getting close to the end of our time, sadly. I have to ask the legacy question. 40 years and it continues apace. But if you had to sort of reflect back on the last 40 years of extraordinary public service that you have rendered to our district and our state and our nation, what would you hope your legacy would be?
Just that I tried to do right in every case, and I didn't always get it right, but I hopefully have an open mind and don't have any preconceived notions about who should win or who should lose, and that I've been faithful to the principles of justice and mercy.
Well, I think that all of those of us who've practiced in this district, and then I've certainly had the privilege of serving with you for a number of years, know that you have been faithful and know that the journey continues. Those of you who are in this room, if many of you have heard, if you've had a case in front of me, you've heard me talk about the longest serving active United States judge in the history of the United States is from North Carolina. His name is Henry Potter. He was a Jefferson appointee, appointed in 1802, served into the Buchanan administration in 1857. So the journey continues, 15 years to go. We'll be sure to come back with a big cake, if not sooner. And I have gotten a special card. I went to the card store and got a back in 1984 reflections on a special year, so we could take you all the way back to know what the average price of a new car was $11,000, a new home was $91,000, gas was $1.21 a gallon. So that's a special card for you, and I would like everyone to give Judge Boyle a big round of applause for his 40 years.